be concerned, you will have the opportunity to do that when you go back to deliberate. Okay. Members of the jury, it is now my duty as judge to instruct you in the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than that given in the instructions of the court. If in these instructions any rule, direction, or idea is repeated or stated in different ways, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others, but you are to consider all the instructions as a whole and regard each in the light of all the others. The order in which the instructions are given has no significance as to their relative importance. An information is but a formal method of accusing a person of a crime and is not of itself any evidence of his guilt. In this case, it is charged in a second amended information that on or between May 1, 2013 and August 8, 2014, defendant committed the offenses of battery constituting domestic violence, strangulation, coercion, preventing or dissuading witness or victim from reporting crime or commencing prosecution, first-degree kidnapping resulting in substantial bodily harm, battery resulting in substantial bodily harm constituting domestic violence, sexual assault, attempt sexual assault, burglary with use of a deadly weapon, first-degree kidnapping with use of a deadly weapon resulting in substantial bodily harm, coercion sexually motivated, battery with use of a deadly weapon constituting domestic violence, battery with intent to commit sexual assault with use of a deadly weapon resulting in substantial bodily harm, attempt murder with use of a deadly weapon, battery with substantial bodily harm, and battery by strangulation, attempt murder in the manner following, to wit: Count 1, battery constituting domestic violence, strangulation. Did then and there willfully, unlawfully, and feloniously use force or violence upon a person with whom said defendant is or was actually residing, and or a person with whom he has had or is having a dating relationship, to wit, Christine McInday, by strangulation. Count 2, coercion. Did then and there willfully, unlawfully, and feloniously use physical force or the immediate threat of such force against Christine McInday with intent to compel her to do or abstain from doing an act which she had the right to do or abstain from doing by said defendant taking away the phone of the said Christine McInday and or preventing her from using it. Count 3, preventing or dissuading witness or victim from reporting crime or commencing prosecution. Did then and there willfully, unlawfully, and feloniously by intimidation or threats prevent or dissuade or hinder or delay Christine McInday from reporting a crime, and or commencing a criminal prosecution, and or causing an arrest, to wit, by said defendant instructing the said Christine McInday not to report to a peace officer the crimes committed against her by said defendant. Count 4, battery constituting domestic violence, strangulation. Did then and there willfully, unlawfully, and feloniously use force or violence upon a person with whom said defendant is or was actually residing, and or a person with whom he has had or is having a dating relationship, to wit, Christine McInday, by strangulation. Count 5, coercion. Did then and there willfully, unlawfully, and feloniously use physical force or the immediate threat of such force against Christine McInday with intent to compel her to do or abstain from doing an act which she had the right to do or abstain from doing, by said defendant taking away the phone of the said Christine McInday and or preventing her from using it. Count 6, preventing or dissuading witness or victim from reporting crime or commencing prosecution. Did then and there willfully, unlawfully, and feloniously by intimidation or threats prevent or dissuade or hinder or delay Christine McInday from reporting a crime and or commencing a criminal prosecution and or causing an arrest, to wit, by said defendant instructing the said Christine McInday not to report to a peace officer the crimes committed against her by said defendant. Count 7, first-degree kidnapping resulting in substantial bodily harm. Did willfully, unlawfully, and feloniously seize, confine, inveigle, entice, decoy, abduct, conceal, kidnap, or carry away Christine McInday, a human being, with the intent to hold or detain the said Christine McInday for the purpose of committing battery with substantial bodily harm, and in fact resulting in substantial bodily harm to Christine McInday while she was detained and or confined. Count 8, battery resulting in substantial bodily harm constituting domestic violence. Did then and there willfully, unlawfully, and feloniously use force or violence upon a person with whom he is or was actually residing and or a person with whom he has had or is having a dating relationship, to wit, Christine McInday, by the said defendant using his hands and or fists to punch the mouth of the said Christine McInday and or by slamming Christine McInday's face into the dashboard, resulting in substantial bodily harm to the said Christine McInday. Count 9, sexual assault. Did then and there willfully, unlawfully, and feloniously sexually assault and subject Christine McInday to sexual penetration, to wit, digital penetration, by said defendant inserting his hand and or fingers into the genital opening of the said Christine McInday against her will or under conditions in which defendant knew or should have known that the said Christine McInday was mentally or physically incapable of resisting or understanding the nature of defendant's conduct. Count 10, sexual assault. Did then and there willfully, unlawfully, and feloniously sexually assault and subject Christine McInday to sexual penetration, to wit, sexual intercourse, by said defendant inserting his penis into the genital opening of the said Christine McInday against her will or under conditions in which defendant knew or should have known that the said Christine McInday was mentally or physically incapable of resisting or understanding the nature of defendant's conduct. Count 11, attempt sexual assault. Did then and there willfully, unlawfully, and feloniously attempt to sexually assault and subject Christine McInday to sexual penetration, to wit, anal intercourse, by said defendant attempting to insert his penis into the anal opening of the said Christine McInday against her will or under conditions in which defendant knew or should have known that the said Christine McInday was mentally or physically incapable of resisting or understanding the nature of defendant's conduct. Count 12, sexual assault. Did then and there willfully, unlawfully, and feloniously sexually assault and subject Christine McInday to sexual penetration, to wit, sexual intercourse, by said defendant inserting his penis into the genital opening of the said Christine McInday against her will or under conditions in which defendant knew or should have known that the said Christine McInday was mentally or physically incapable of resisting or understanding the nature of defendant's conduct. Count 13, burglary with use of a deadly weapon. Did then and there willfully, unlawfully, and feloniously enter with intent to commit battery and or a felony, to wit, kidnapping and or coercion and or sexual assault, that certain building occupied by Christine McInday located in Las Vegas, Nevada, Clark County, Nevada, with use of a deadly weapon, to wit, a knife. Count 14, first-degree kidnapping with use of a deadly weapon resulting in substantial bodily harm. Did willfully, unlawfully, and feloniously seize, confine, inveigle, entice, decoy, abduct, conceal, kidnap, or carry away Christine McInday, a human being, with the intent to hold or detain the said Christine McInday for the purpose of committing sexual assault and or murder and or battery resulting in substantial bodily harm, with use of a deadly weapon, to wit, a knife, and in fact resulting in substantial bodily harm to Christine McInday while she was detained and or confined. Count 15, coercion sexually motivated. Did then and there willfully, unlawfully, and feloniously use physical force or the immediate threat of such force against Christine McInday with intent to compel her to do or abstain from doing an act which she had the right to do or abstain from doing, by said defendant causing the said Christine McInday to disrobe and or take a shower. One of the purposes for which the defendant committed the offense was defendant's sexual gratification. Count 16, battery resulting in substantial bodily harm constituting domestic violence. did then and there willfully, unlawfully, and feloniously use force or violence upon a person with whom he is or was actually residing, and or a person with whom he has had or is having a dating relationship, to wit, Christine McInday, by said defendant using his fists to punch the said Christine McInday in the face and or eyes, resulting in substantial bodily harm to the said Christine McInday. Count 17, battery resulting in substantial bodily harm constituting domestic violence. Did then and there willfully, unlawfully, and feloniously use force or violence upon a person with whom he is or was actually residing, and or a person with whom he has had or is having a dating relationship, to wit, Christine McInday, by said defendant using his fists to punch the said Christine McInday in the face and or nose, resulting in substantial bodily harm to the said Christine McInday. Count 18, battery resulting in substantial bodily harm constituting domestic violence. Did then and there willfully, unlawfully, and feloniously use force or violence upon a person with whom he is or was actually residing, and or a person with whom he has had or is having a dating relationship, to wit, Christine McInday, by said defendant using his fists to punch the said Christine McInday in the mouth and or teeth, resulting in substantial bodily harm to the said Christine McInday. Count 19, battery resulting in substantial bodily harm constituting domestic violence. Did then and there willfully, unlawfully, and feloniously use force or violence upon a person with whom he is or was actually residing, and or a person with whom he has had or is having a dating relationship, to wit, Christine McInday, by said defendant using his fists and or feet to punch and or kick the leg of the said Christine McInday, and or using manner and means unknown, resulting in substantial bodily harm to the said Christine McInday. Count 20, battery resulting in substantial bodily harm constituting domestic violence. Did then and there willfully, unlawfully, and feloniously use force or violence upon a person with whom he is or was actually residing, and or a person with whom he has had or is having a dating relationship, to wit, Christine McInday, by said defendant using his feet to kick the ribs and or abdomen of the said Christine McInday, resulting in substantial bodily harm to the said Christine McInday. Count 21, battery with use of a deadly weapon constituting domestic violence. Did then and there willfully, unlawfully, and feloniously use force or violence upon a person with whom he is or was actually residing, and or a person with whom he has had or is having a dating relationship, to wit, Christine McInday, with use of a deadly weapon, to wit, a knife, by said defendant cutting and or poking the said Christine McInday in the hand with said knife. Count 22, battery with use of a deadly weapon constituting domestic violence. Did then and there willfully, unlawfully, and feloniously use force or violence upon a person with whom he is or was actually residing, and or a person with whom he has had or is having a dating relationship, to wit, Christine McInday, with use of a deadly weapon, to wit, a knife, by said defendant cutting and or poking the said Christine McInday in the ear with said knife. Count 23, battery with use of a deadly weapon constituting domestic violence. Did then and there willfully, unlawfully, and feloniously use force or violence upon a person with whom he is or was actually residing, and or a person with whom he has had or is having a dating relationship, to wit, Christine McInday, with use of a deadly weapon, to wit, a knife, by said defendant cutting and or poking the said Christine McInday in the head and or hair with said knife. Count 24, battery with intent to commit sexual assault. Did then and there willfully, unlawfully, and feloniously use force or violence upon the person of another, to wit, Christine McInday, with the intent to commit sexual assault, by slapping and or punching and or kicking the said Christine McInday. Count 25, sexual assault with use of a deadly weapon resulting in substantial bodily harm. Did then and there willfully, unlawfully, and feloniously sexually assault and subject Christine McInday to sexual penetration, to wit, digital penetration, by said defendant inserting his hand and or fingers into the genital opening of the said Christine McInday, against will or under conditions in which the perpetrator knows or should know that the said Christine McInday was mentally or physically incapable of resisting or understanding the nature of defendant's conduct, with use of a deadly weapon, to wit, a knife, resulting in substantial bodily harm. Count 26, attempt murder with use of a deadly weapon. Did then and there willfully, unlawfully, feloniously, and with malice aforethought attempt to kill Christine McInday, a human being, with use of a deadly weapon, to wit, by beating the said Christine McInday for approximately 2 hours, and or going to the kitchen to retrieve a knife to kill Christine McInday, and or contacting numerous family members and friends of Christine McInday, acting as though he was Christine McInday, and telling them they would be unable to reach her for a period of time, all with the intent to murder Christine McInday. Count 27, battery resulting in substantial bodily harm. Did then and there willfully, unlawfully, and feloniously use force or violence upon the person of another, to wit, Corey Thomas, by said defendant using his fists to punch the face of the said Corey Thomas, resulting in substantial bodily harm to the said Corey Thomas. Count 28, battery resulting in substantial bodily harm. Did then and there willfully, unlawfully, and feloniously use force or violence upon the person of another, to wit, Corey Thomas, by said defendant biting the face and or arm of the said Corey Thomas, resulting in substantial bodily harm to the said Corey Thomas. Count 29, battery resulting in substantial bodily harm. Did then and there willfully, unlawfully, and feloniously use force or violence upon the person of another, to wit, Corey Thomas, by said defendant beating the said Corey Thomas, dislocating his shoulder, resulting in substantial bodily harm to the said Corey Thomas. Count 30, battery by strangulation. Did then and there willfully, unlawfully, and feloniously use force or violence upon the person of another, to wit, Corey Thomas, by strangulation. Count 31, battery by strangulation. Did then and there willfully, unlawfully, and feloniously use force or violence upon the person of another, to wit, Corey Thomas, by strangulation. Count 32, battery by strangulation. Did then and there willfully, unlawfully, and feloniously use force or violence upon the person of another, to wit, Corey Thomas, by strangulation. Count 33, attempt murder. Did then and there willfully, unlawfully, feloniously, and with malice aforethought attempt to kill Corey Thomas by strangling Corey Thomas and or placing him in a chokehold. Count 34, preventing or dissuading witness or victim from reporting crime or commencing prosecution. Did then and there willfully, unlawfully, and feloniously by intimidation or threats prevent or dissuade or hinder or delay Corey Thomas from reporting a crime and or commencing a criminal prosecution and or causing an arrest, to wit, by said defendant instructing the said Corey Thomas not to report to a peace officer the crimes committed against him by said defendant. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of the case and determine whether or not the defendant is guilty of one or more of the offenses charged. Each charge and the evidence pertaining to it should be considered separately. The fact that you may find a defendant guilty or not guilty as to one of the offenses charged should not control your verdict as to any other defendant or offense charged. Battery means any willful and unlawful use of force or violence upon the person of another. A willful act is one done intentionally and not accidentally. If you determine that a battery has occurred, you must also determine whether or not that battery constituted domestic violence. Battery constituting domestic violence occurs when an individual commits a battery upon his spouse, former spouse, any other person to whom he is related by blood or marriage, a person with whom he is or was actually residing, a person with whom he has had or is having a dating relationship, or a person with whom he has a child in common. Dating relationship means frequent intimate associations, primarily characterized by the expectation of affectional or sexual involvement. The term does not include a casual relationship or an ordinary association between persons in a business or social context. For counts 21, 22, and 23, if you determine that a battery has occurred, you must also determine whether or not a deadly weapon was used during the commission of that crime. Battery with use of a deadly weapon occurs when a person unlawfully uses force or violence upon a person of another with the use of a deadly weapon. Any harmful or offensive, unconsented touching with the deadly weapon, however slight, constitutes sufficient force or violence upon the person of another. You must also determine whether this battery constituted domestic violence. Battery with use of a deadly weapon constituting domestic violence occurs when a person unlawfully uses force or violence upon his spouse, former spouse, any other person to whom he is related by blood or marriage, a person with whom he is or was actually residing, a person with whom he has had or is having a dating relationship, or a person with whom he has a child in common with the use of a deadly weapon. As used in these instructions, excuse me, a deadly weapon means any instrument which, if used in the ordinary manner contemplated by its design and construction, will or is likely to cause substantial bodily harm or death, or any weapon, device, instrument, material, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing substantial bodily harm or death. In order to use a deadly weapon, there need not be conduct which actually produces harm, but only conduct which produces a fear of harm or force by means or display of the deadly weapon in aiding the commission of the crime. For counts 8, 16, 17, 18, 19, 20, 27, 28, and 29, if you determine that a battery has occurred, you must also determine if the defendant caused substantial bodily harm. As used in these instructions, substantial bodily harm means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss or impairment of the functions of any bodily member or organ, or prolonged physical pain. Prolonged physical pain encompasses a physical suffering or injury that lasts longer than the pain immediately resulting from the wrongful act. For counts 8, 16, 17, 18, 19, and 20, if you determine that a battery resulted in substantial bodily harm has occurred, you must also determine if it constituted domestic violence. Battery resulting in substantial bodily harm constituting domestic violence occurs when a person unlawfully uses force or violence upon his spouse, former spouse, any other person to whom he is related by blood or marriage, a person with whom he is or was actually residing, a person with whom he has had or is having a dating relationship, or a person with whom he has a child in common, which results in substantial bodily harm. For counts 1, 4, 30, 31, and 32, if you determine that a battery has occurred, you must also determine whether or not that battery was committed by strangulation. Battery by strangulation means to commit a battery by intentionally impeding the normal breathing or circulation of the blood by applying pressure on the throat or neck or by blocking the nose or mouth of another person in a manner that creates a risk of death or substantial bodily harm. For counts 1 and 4, battery constituting domestic violence strangulation occurs when an individual batters by strangulation his spouse, former spouse, any other person to whom he is related by blood or marriage, a person with whom he is or was actually residing, a person with whom he has had or is having a dating relationship, or a person with whom he has a child in common. Any person who uses violence upon another person or threatens violence or injury to another person with the specific intent to compel another to do or abstain from doing an act which such other person has a right to do or abstain from doing is guilty of coercion with force. If you determine beyond a reasonable doubt that coercion occurred, but no violence or threat of violence was used, then the proper verdict would be coercion without force. This instruction only applies to count 15, coercion sexually motivated. If you find the defendant guilty of coercion, you must also determine whether the state has proven beyond a reasonable doubt that the coercion was sexually motivated. Coercion is sexually motivated if one of the purposes for which the person committed the offense was his or her sexual gratification. A person who subjects another person to sexual penetration against the victim's will or under conditions in which the perpetrator knows or should know that the victim is mentally or physically incapable of resisting or understanding the nature of his or her conduct is guilty of sexual assault. Sexual penetration means cunnilingus, fellatio, or any intrusion, however slight, of any part of a person's body or any object manipulated or inserted by a person into the genital or anal openings of the body of another, including sexual intercourse in its ordinary meaning. Evidence of ejaculation is not necessary. Digital penetration is the placing of one or more fingers of the perpetrator into the genital or anal opening of another person. Sexual intercourse is the intrusion, however slight, of the penis into the genital opening of another person. Anal intercourse is the intrusion, however slight, of the penis into the anal opening of another person. Physical force is not necessary in the commission of sexual assault. The crucial question is not whether a person was physically forced to engage in a sexual assault, but whether the act was committed without her consent or under conditions in which the defendant knew or should have known the person was incapable of giving her consent or understanding the nature of the act. There is no consent where a person is induced to submit to the sexual act through fear of death or serious bodily injury. A person is not required to do more than her age, strength, surrounding facts, and attending circumstances make it reasonable for her to do to manifest opposition to a sexual assault. Submission is not the equivalent of consent. While consent inevitably involves submission, submission does not inevitably involve consent. Lack of protest by a victim is simply one among the totality of circumstances to be considered by the jury. There is no requirement that the testimony of a victim of sexual assault be corroborated, and her testimony standing alone, if believed beyond a reasonable doubt, is sufficient to sustain a verdict of guilty. It is a defense to the charge of sexual assault that the defendant entertained a reasonable and good faith belief that the alleged victim consented to engage in sexual intercourse. If you find such reasonable good faith belief, even if mistaken, you must give the defendant the benefit of the doubt and find him not guilty of sexual assault. A belief that is based upon ambiguous conduct by the alleged victim, that is the product of force, violence, duress, menace, or fear of immediate and unlawful bodily injury on the person of another, is not a reasonable and good faith belief. Where multiple sexual acts occur as part of a single criminal encounter, a defendant may be found guilty for each separate or different act of sexual assault. Where a defendant commits a specific type of act constituting sexual assault, he may be found guilty of more than one count of that specific type of act of sexual assault if 1. There is an interruption between the acts which are of the same specific type, 2. Where the acts of the same specific type are interrupted by a different specific type of sexual assault, or 3. For each separate object manipulated or inserted into the genital or anal opening of another. Only one sexual assault occurs when a defendant's actions were of one specific type of sexual assault, and those acts were continuous and did not stop between the acts of that specific type. 4 count 25. If you find that a sexual assault has occurred, you must also determine if the defendant used a deadly weapon during the commission of the crime. You have previously been instructed on the definition of deadly weapon. If you determine that a sexual assault has occurred, you must also determine if the defendant caused substantial bodily harm. You have previously been instructed on the definition of substantial bodily harm. Any person who commits a battery upon another with the specific intent to commit a sexual assault is guilty of the offense of battery with intent to commit sexual assault. When it is impossible to commit a particular crime without committing at the same time and by the same conduct another offense of lesser grade or degree, the latter is, with respect to the former, a lesser included offense. If one count of an information charges a defendant with committing an offense and another count charges a lesser included offense, the defendant may not be convicted of both counts. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of either of the offenses charged, he may also be found guilty of any uncharged lesser included offense if the evidence is sufficient to establish his guilt of such lesser offense beyond a reasonable doubt. The offense of sexual assault necessarily includes the lesser offense of open and gross lewdness. Open and gross lewdness is committed when a person intentionally commits an act of gross lewdness in a public place or in a private place with the intent to offend the observer. Lewdness means sexual conduct which is obscene or indecent. Gross means conduct which is glaringly noticeable or obviously objectionable. Every person who willfully seizes, confines, inveigles, entices, decoys, abducts, conceals, kidnaps, or carries away any person by any means whatsoever with the intent to hold or detain, or who holds or detains the person, 1, for ransom or reward, or 2, for the purpose of committing sexual assault, extortion, or robbery upon or from the person, or 3, for the purpose of killing the person or inflicting substantial bodily harm upon him, or 4, to exact from relatives, friends, or any other person any money or valuable thing for the return or disposition of the kidnapped person, is guilty of first-degree kidnapping. The law does not require the person being kidnapped to be carried away for any minimal distance. While a guilty verdict must be unanimous, you need not be unanimous on the means or the theory of first-degree kidnapping in arriving at your verdict. An act is knowingly done if done voluntarily and intentionally, and not because of mistake or accident or other innocent reason. The intention or purpose for which the victim was held against his or her will is a question of fact to be determined by your consideration of the evidence. The intention may be inferred from the defendant's conduct and all other circumstances. If substantial bodily harm results to the kidnapped person during the act of the kidnapping, or the detention and confinement of the person, or in an attempt to escape or an escape therefrom, regardless of alleged purpose of the kidnapping, the defendant is guilty of first-degree kidnapping resulting in substantial bodily harm. You have previously been instructed as to the definition of substantial bodily harm. You are instructed that if you find the defendant guilty of first-degree kidnapping, you must also determine whether or not a deadly weapon was used in the commission of this crime. You have previously been instructed as to the definition of deadly weapons. In order for you to find the defendant guilty of first-degree kidnapping, in addition to the associated offense of sexual assault, you must also find beyond a reasonable doubt either 1, that the movement of the victim was not incidental to the sexual assault, 2, that any incidental movement of the victim substantially increased the risk of harm to the victim over and above that necessarily present in the commission of the sexual assault, 3, that any incidental movement of the victim substantially exceeded that required to complete the sexual assault, 4, that the victim was physically restrained and such restraint substantially increased the risk of harm to the victim, or 5, that the movement or restraint had an independent purpose or significance. Physically restrained includes but is not limited to tying, binding, or taping. when it is impossible to commit a particular crime without committing at the same time and by the same conduct another offense of lesser, greater degree, the latter is, with respect to the former, a lesser included offense. If one count of an information charges a defendant with committing an offense, and another count charges a lesser included offense, the defendant may not be convicted of both counts. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of either of the offenses charged, he may also be found guilty of any uncharged lesser included offense if the evidence is sufficient to establish his guilt of such lesser offense beyond a reasonable doubt. The offense of first-degree kidnapping necessarily includes the lesser offense of false imprisonment. False imprisonment is the unlawful violation of the personal liberty of another, consisting in confinement or detention without sufficient legal authority. For count 14, if you determine that false imprisonment occurred, you must also determine whether it occurred with the use of a deadly weapon. You have previously been instructed on the definition of a deadly weapon. A person who, by intimidating or threatening another person, prevents or dissuades a victim of a crime, a person acting on behalf of the victim or a witness from A, reporting a crime or possible crime to a judge, peace officer, parole or probation officer, prosecuting attorney, warden or other employee at an institution of the Department of Corrections, or superintendent or other employee at a juvenile correctional institution. B, commencing a criminal prosecution or a proceeding for the revocation of a parole or probation, or seeking or assisting in such a prosecution or proceeding. Or C, causing the arrest of a person in connection with a crime, or who hinders or delays such a victim, agent, or witness in an effort to carry out any of those actions, is guilty of preventing or dissuading witness or victim from reporting crime or commencing prosecution. The elements of an attempt to commit a crime are 1, the intent to commit the crime, 2, performance of some act towards its commission, and 3, failure to consummate its commission. Attempt murder is the performance of an act or acts which tend but fail to kill a human being when such acts are done with express malice, namely with the deliberate intention unlawfully to kill. For count 26, the defendant is charged with attempt murder with use of a deadly weapon. If you find the defendant guilty of attempt murder, you must also determine whether or not he used a deadly weapon during the commission of the crime. You have previously been instructed as to the definition of deadly weapon. When a person has once done things which constitute an attempt to commit a crime, he cannot avoid responsibility by failing to proceed further to commit that crime, either by reason of voluntarily abandoning his purpose or because he was prevented or interfered with in completing the crime. An act done with intent to commit a crime and tending but failing to accomplish it is an attempt to commit that crime. The act done must be an overt act. It must go beyond mere preparation to commit the crime and tend to accomplish it. The preparation consists in devising or arranging the means or measures necessary for the commission of the offense. The attempt is the direct movement toward the commission after the preparations are made. A person who, by day or night, enters any house, room, apartment with the intent to commit battery on any person or any felony, kidnapping, coercion, or sexual assault is guilty of burglary. As aforementioned, battery is defined as the willful and unlawful use of force or violence upon the person of another. Consent to enter is not a defense to the crime of burglary so long as it is shown that entry was made with the specific intent to commit an assault and or a battery and or a felony therein. Defendant is charged with burglary with use of a deadly weapon. If you find the defendant guilty of burglary, you must also determine whether or not a deadly weapon was used in the commission of the crime. Every person who commits the crime of burglary who has in his possession or gains possession of any firearm or deadly weapon at any time during the commission of the crime, at any time before leaving the structure or upon leaving the structure, is guilty of burglary with use of a deadly weapon. Defendant has been charged with both general intent crimes and specific intent crimes. General intent is the intent to do that which the law prohibits. It is not necessary for the prosecution to prove that the defendant intended the precise harm or the precise result which eventuated. On the other hand, specific intent is the intent to accomplish the precise act which the law prohibits. The state must prove that the defendant knowingly did the act which the law forbids, purposely intending to violate that law. You are instructed that the following crimes are general intent crimes: battery constituting domestic violence, strangulation; battery resulting in substantial bodily harm constituting domestic violence; sexual assault; battery with use of a deadly weapon constituting domestic violence; sexual assault with use of a deadly weapon resulting in substantial bodily harm are general intent crimes. You are instructed that the following crimes are specific intent crimes: coercion, preventing or dissuading witness or victim from reporting crime or commencing prosecution; first-degree kidnapping resulting in substantial bodily harm; attempt sexual assault; burglary with use of a deadly weapon; first-degree kidnapping with use of a deadly weapon resulting in substantial bodily harm; coercion sexually motivated; battery with intent to commit sexual assault; attempt murder with use of a deadly weapon, and attempt murder are specific intent crimes. No act committed by a person while in a state of voluntary intoxication shall be deemed less criminal by reason of his condition when the defendant is charged with a general intent crime. Voluntary use of drugs or alcohol is not a defense to any general intent crime. However, when the defendant is charged with a specific intent crime, you should consider the defendant's voluntary intoxication in deciding whether the defendant possessed the required specific intent at the time of the commission of the alleged crime. If the evidence shows that a defendant was intoxicated at the time of the alleged crime, you should consider that fact in deciding whether or not the defendant had the required specific intent. The flight of a person immediately after the commission of a crime or after he is accused of a crime is not sufficient in itself to establish his guilt, but is a fact which, if proved, may be considered by you in light of all other proved facts in deciding whether he is guilty or not guilty. Whether or not evidence of flight shows a consciousness of guilt and the significance to be attached to such a circumstance are matters for your deliberation. To constitute the crime charged, there must exist a union or joint operation of an act forbidden by law and an intent to do the act. The intent with which an act is done is shown by the facts and circumstances surrounding the case. Do not confuse intent with motive. Motive is what prompts a person to act. Intent refers only to the state of mind with which the act is done. Motive is not an element of the crime charged, and the state is not required to prove motive on the part of the defendant in order to convict. However, you may consider evidence of motive or lack of motive as a circumstance of the case. The defendant is presumed innocent until the contrary is proved. This presumption places upon the state the burden of proving beyond a reasonable doubt every element of the crime charged, and that the defendant is the person who committed the offense. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt as would govern or control a person in the more weighty affairs of life. If the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they can say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, he is entitled to a verdict of not guilty. You are here to determine the guilt or innocence of the defendant from the evidence in the case. You are not called upon to return a verdict as to the guilt or innocence of any other person. So, if the evidence in the case convinces you beyond a reasonable doubt of the guilt of the defendant, you should so find, even though you may believe one or more persons are also guilty. The evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts admitted or agreed to by counsel. There are two types of evidence, direct and circumstantial. Direct evidence is the testimony of a person who claims to have personal knowledge of the commission of the crime which has been charged, such as an eyewitness. Circumstantial evidence is the proof of a chain of facts and circumstances which tend to show whether the defendant is guilty or not guilty. The law makes no distinction between the weight to be given either direct or circumstantial evidence. Therefore, all of the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorneys stipulate to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proved. You must not speculate to be true any insinuation suggested by a question asked a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must disregard any evidence to which an objection was sustained by the court and any evidence ordered stricken by the court. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. The credibility or believability of a witness should be determined by his or her manner upon the stand, his or her relationship to the parties, his or her fears, motives, interests, or feelings, his or her opportunity to have observed the matter to which he or she testified, the reasonableness of his or her statements, and the strength or weakness of his or her recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his or her testimony which is not proved by other evidence. A witness who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation is an expert witness. An expert witness may give his or her opinion as to any matter in which he or she is skilled. You should consider such expert opinion and weigh the reasons, if any, given for it. You are not bound, however, by such an opinion. Give it the weight to which you deem it entitled, whether that be, whether that be great or slight, and you may reject it if, in your judgment, the reasons given for it are unsound. Although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in the light of common experience, keeping in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. In your deliberation, you may not discuss or consider the subject of punishment, as that is a matter which lies solely with the court. Your duty is confined to the determination of the guilt or innocence of the defendant. It is a constitutional right of a defendant in a criminal trial that he may not be compelled to testify. Thus, the decision as to whether he should testify is left to the defendant on the advice and counsel of his attorney. You must not draw any inference of guilt from the fact that he did not testify, nor should this fact be discussed by you or enter into your deliberations in any way. Evidence that the defendant committed offenses other than that for which he is on trial, if believed, was not received and may not be considered by you to prove that he is a person of bad character, or to prove that he has a disposition to commit crimes. Such evidence was received and may be considered by you only for the limited purpose of proving the defendant's motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. You must weigh this evidence in the same manner as you do all other evidence in the case. When you retire to consider your verdict, you must select one of your members to act as foreperson, who will preside over your deliberation and will be your spokesperson here in court. During your deliberation, you will have all the exhibits which were admitted in new evidence, these written instructions, and forms of verdict which have been prepared for your convenience. Your verdict must be unanimous. As soon as you have agreed upon a verdict, have it signed and dated by your foreperson, and then return with it to this room. If, during your deliberation, you should desire to be further informed on any point of law, or hear again portions of the testimony, you must reduce your request to writing signed by the foreperson. The officer will then return you to court where the information sought will be given you in the presence of and after notice to the district attorney and the defendant and his counsel. Playbacks of testimony are time-consuming and are not encouraged unless you deem it a necessity. Should you require a playback, you must carefully describe the testimony to be played back so that the court recorder can arrange your notes. Remember, the court is not at liberty to supplement the evidence. Jurors are not allowed to read, watch, or listen to any report of or commentary on the trial, or any person connected with this trial, by any medium of information, including without limitation, newspapers, television, the internet, or radio, or to conduct any independent research, investigation, or experiments regarding this case. Now you will listen to the arguments of counsel, who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind that it is your duty to be governed in your deliberation by the evidence as you understand it and remember it to be, and by the law as given to you in these instructions, with the sole fixed and steadfast purpose of doing equal and exact justice between the defendant and the state of Nevada. All right.